Hello students. Today the topic of the lecture is Introduction to Intellectual Property Rights and its Types. This is intended for BSc Microbial and Food Technology third year students studying Entrepreneurship and Intellectual Property Rights by Dr. Sandeep Kaur, Department of Food Science, MCM DAV College for Women, Chandigarh. The objectives of this lecture is to give introduction to the students on intellectual property rights, that is IPR, its different types with examples, to apprise the students about the significance and role of IPR in promoting and protecting innovation, creativity, and knowledge. Now, firstly, students, you should be knowing that there are two different types of properties. When we talk about properties, we talk as tangible property and intangible property. Now, tangible property is something which is tangible, that is, which includes physical objects such as land, household goods, cars, right, which can be seen, which can be felt. These are tangible property. The second is intangible property. The intangible property is something which does not have, a physical feeling. You can't see it, you cannot feel it. It's not like a car or a good that has some dimensions. It's intangible property. It is a property which is actually comes up from humans' intellect, such as patents, copyright, designs that will be talked. So, when we talk about intellectual property is a kind of intangible property, and it is a result of creative efforts and come from one's own intellect, and thus cannot be materially measured as a tangible property, right? So the intangible assets that are with us, for example, our brain, the working of because of the working of our brain, whatever output we are generating, our ideas, our out of the box thinking, these are our intangible assets. Now, next is what is intellectual property? That is a definition by WIPO. Now, right now, WIPO you must not be knowing. WIPO stands for World Intellectual Property Organization. It is the main organization which deals with intellectual property. So that we will touch towards the end of this lecture. Now, what is the definition of intellectual property, or in short, we also call it as IP? Intellectual property or IP refers to creations of the mind, inventions, literary and artistic work, symbols, names, images, designs. IP means a property which is created out of a person's intellect, and the legal rights conferred on such property are called IPR. The legal rights conferred on such property which come out of one's own mind, which is intangible, they are called IPR. And IPR is actually a result of out of the box thinking. Think away from the normal. IP has its own value and it needs to be protected. And it is protected by IPR. That is the rights conferred to protect the IP is called IPR. In a more sophisticated language or in a well-defined manner, IPR are a bundle of exclusive rights over creations of the mind. Or you can say that these are the set of exclusive rights governed by law that prevent others from using, manufacturing, copying, selling, distributing the product, technology, design, symbols, lines, idea, literary work without the legal consent of the owner for a given period of time. It's very essential that when we are talking about definition, we need to include the complete definition. Given period of time is very essential, because as we move towards this lecture, you will understand why I'm saying so. If it's a patent, you need to know that it is for 10 years. If it's a geographical indication, it is for another some different period of time. So every IPR has different periods for which it is protected, right? So once again, I repeat that IPR are the set of exclusive rights governed by law that prevent others from using that IP without the legal consent of the owner for a specific period of time. Now, intellectual property can be divided into two categories. First is industrial property, which includes patents for inventions, patents, trademarks, industrial designs, and geographical indications. And second category में आता है copyright. Copyright covers the literary works such as novels, poems, plays, artistic work, drawings, photographs, sculptures, paintings. That comes under copyright and related rights. So intellectual property can be divided into two categories. First is industrial property and second is copyright. This is a image which is which includes different types of IPR. IPR, as I told you, intellectual property can be divided into two categories: industrial property and copyright and related rights. Industrial property, we have industrial design, patents, trademarks, service marks, trade secrets, geographical indications, layout, plant varieties, and farmers' right. And the second category, as I told you, was the copyright. So one by one, we will slowly go into each, touching each. What do you mean by industrial design? What do you mean by patent? What do you mean by trade secret? And all these, and we'll be covering the different types of IPR. Let's come one by one. First is trademark. Trademark. This is a symbol for trademark R, right? Trademark is a recognizable sign, design, or expression which identifies products or services of a particular source from those of others. The renewable time is 10 years and validity is as long as one pays for the trademark. So the words, letters, numerals, pictures, shapes and colors, as well as the combinations of any of these, any of the shape and the picture, color and the design and the lines, for example, McDonald's, the M and I'm loving it, that slogan, all this comes under trademark. If you look at the bottle here, this is the bottle has its trademark, the shape, the name imprinted on it, Coca-Cola. Now the Nike, the logo type, this is a symbol of McDonald's. This is a slogan. IBM has its own pattern of line, Pillsbury, right? Android. So these are the different trademarks, and nobody can copy these trademarks without the consent of the owner. These trademarks are protected. So this is one category of IPR, which is called trademarks, which is a recognizable sign or expression which identifies products of a particular source. If you have this trademark, you know that it belongs to Apple, and nobody else can use that. Trade secrets. Another category of IPR are trade secrets. Sorry. Trade secrets. A trade secret is a formula, practice, process, instrument, pattern, commercial method, can be a protocol, okay, which is whose information is not known. Actually, trade secret is a secret which is kept as a secret for the whole life. And why it is a secret? Because of that secret, there is a lot of benefit which is associated to the business. It is giving benefit to the business. It is economic advantage over other competitors or customers. So trade secret means information which is kept confidential or as a secret, and only few people who own that trade secret know it, and they have to maintain that secret so that they get the advantage over other competitors. And it is fundamentally it is a do it yourself type of protection. Not much the other people will do about it. You have to do it yourself. And there is also a very important thing that there are only two people alive who know the recipe of Coca-Cola, and they are not allowed to travel on the same plane. In case it crashes, you're gone with the trade secret. So trade secrets are actually generally the formulas, protocols, programs which give you a benefit, a business benefit and it is a do it type yourself protection. Then third category is geographical indication, very important IPR. The third category of IPR is geographical indication or GI. It is a sign which is used on products that have a specific geographical origin and possess qualities or a reputation that are due to that origin. Right? For example, the common example that I would like to give here is basmati rice. When any rice packet has the term basmati rice, that you are actually using a geographical indication, because basmati rice indicates the particular origin that it is of this rice category is of a particular origin in areas of Haryana, Punjab, where basmati grows. Darjeeling tea, it again tells you about the specific geographical origin. It gives an added quality to the tea. Darjeeling tea, Bikaner. Then we have the Banarsi sari, the Alfonso mango, Kanchipuram sari, right? Cheese, Swiss cheese or Swiss watches, they have that added geographical indication. They actually help to identify the product's origin, and it adds value to the product. So this geographical indication is actually valid for 10 years. And you need to register your product for this geographical indication. The application for registration can be an association of persons, organizations, and you need to, for example, if you are have tea, you want to, sell your tea on the packet, you want to write Darjeeling tea, you need to show that it actually belongs to Darjeeling, and you get that IPR registered, the geographical indication registered for further using it on your product. Fourth category, very, very important, is copyright. As I told you, intellectual property can be divided into two categories: industrial property, which is my patents, industrial designs, trademarks, all these comes. And then we have on the second side, we have the copyright. Copyright is exclusive legal right that prevents to reproduce an original work of authorship fixed in any tangible medium of expression. Very important. So just read the line. Copyright is an exclusive legal right that prevents to reproduce an original work of authorship which is fixed in any tangible medium of expression. Can be fixed in form of a book, can be fixed in the form of a sculpture, can be fixed in the form of a Veda or a music CD. So you cannot copy that original work which is already fixed in any tangible medium. You cannot reproduce that work. You cannot display that work publicly in front of others. And even you cannot prepare derivative works based on the original work. So this is a right which prevents you to reproduce that original work which is fixed in some form of tangible medium. So here tangible medium comes in, although we are talking of an intangible asset. So if it is fixed in a tangible form, a book form, a painting form, a sculpture form, you cannot reproduce it. You cannot make a similar painting and sell it in your name. You cannot display the work, say for example, a music, original music work. You cannot display the same music or perform the same art, drama, music, choreography, which is without the consent of the author. So copyright prevents copying of only the expression. This doesn't mean that if you can't listen to the music, who's किसी और का म्यूजिक आप उसे सुन सकते हो, you can buy the CDs, you can hear it, but you cannot copy the expression and display it public in other people in your name. That is important. You can read the books, of course, but you cannot start copying those lines and then publishing it in your name publicly. That is wrong. A closely associated field is copyright and related rights, or rights related to copyright that encompass rights similar or identical to those of copyright, which are of shorter duration. So what is all actually covered by copyright? If you look here in the picture itself, it shows literary work, films, drama, music, artistic, sound recordings, sculptural works, all these expression, you cannot copy the expression. So these are the different Copyright, which are broadly categorized into literary, dramatic, artistic, musical work, sound recordings, films, broadcast. Literary work also includes a table or a compilation other than a database, a computer program, a database. These also come under the literary work. On the right side, I have written the copyright holder of the work can authorize or prohibit its reproduction in all forms, including print form or sound recording, that you are making duplicate CDs and selling in the market without having the copyright consent from the owner. You cannot broadcast it. You cannot translate it into other languages. You cannot adapt it or modify it in the form of a novel or screenplay without getting the copyright permission from the owner. So that is the important point. Very, very important IPR. So till now we have studied about trademarks, trade secrets, geographical indications, and copyright. The fifth very important IPR is patents. Patent is an exclusive right. It is actually called a negative right. I'll tell you why. Patent is even copyright is a negative right because it prohibits the copying of an expression. Patent is an exclusive right granted for an invention, a product or process that provides a new way of doing something or that offers a new technical solution to a problem. It is an exclusive right granted for your invention. That invention can be a product patent, that is a patent which is given for producing a completely new product or a completely new technology, a totally different way of doing a same thing, but having a technical advantage, or answer to a long-standing problem. Your technology is an answer to a long-standing problem, or you have done something in a totally different way which is giving a technical advantage over the existing methods which were used to do that. So it can be a product or it can be a process. Protection is granted for how much time? It's 20 years from the date. Now this is very important. Whenever you talk about patent, you say it is 20 years from the date of filing the application, not 28 from the day you have been granted the patent. Patent granting takes time. It takes around 1.5 to 2 years also, maybe more than that. But if you are successful in getting a patent, your patent will be valid for a period of 20 years, not from the day the officer said, yes, we grant you patent. No, not from that day, but from the date the application was filed. When the first time you went to the office with your complete form 1 and you have been given a maybe a temporary patent number, from that day of filing your application, your first application, your patent will now be valid. So that is a very important point when you talk about the period of protection for patent. Always you need to write this word that it's 20 years from the date of filing of application. Now the patent right, as I told you, is actually a negative right because it excludes others. It excludes others from making the invention, using the invention, selling the invention, offering the invention, and importing the invention. 5 things. Making it. Now the invention can be a product patent or a process patent. Anything. So we are talking because patents are given for your innovation, for an invention, not for artistic work. I'm very clear that for that thing copyright is there. Patent is generally your scientific inventions that you have, and it is a negative right conferred for 20 years from the time filing the first application. Patent has the right to exclude others from making the invention, using the invention, selling the invention, offering the invention, and importing the invention. These 5 things you need to uh, remember. Now, one can get patent, as I told you, in product as well as in process. Initially, there were certain constraints, but after the amendments of the Indian Patent Act 1970, product patents and process patents both are valid. So one can get patent in product as well as process. Altogether a new product, useful way to do things, a modification. But remember, the modification should have a clear-cut advantage, a technical advantage for the customer or for the user as compared to the older version. Very important IPR is industrial design. Now, the sixth important IPR is industrial design. Industrial design refers to the ornamental or aesthetic aspect of an article. Remember, when you're talking of industrial design patents are always given when we talk about patent and patentability in our next lecture. Patents are always given for utility, for some industrial application. But unlike patent, industrial design is always given uh, is has nothing to do with utility. It is generally design is something which increases the aesthetic value of a particular product. Right? It is not related to any technical utility. If it is related to technical utility, then you have to go under this previous IPR. So this IPR, industrial design, is basically refers to the ornamental or aesthetic aspect of an article, and a design may consist of a three-dimensional feature such as the shape or surface of an article, or two-dimensional feature, patterns, lines. Some, like for example, watches and jewelry का अपना एक design होता है. Jewelry has its own design, cars have their own design, and similarly we have the architectural structures which have their own design. So all this comes under industrial design. You get to registered your industrial design so that it gets protected and you get a certificate is issued. So after you get the certificate issued, the term of protection granted is generally 5 years with the possibility of further renewable with the fees up to 15 years. Very important IPR is plant varieties and farmers' right. Plant varieties and farmers' right. Plant varieties or plant breeders' right, also known as plant variety right or plant breeders' right. These are the rights which are granted to the breeder of a new variety of plant. This is altogether different right, especially taking care of the new plant varieties which come. So you give right to the breeder of that new plant variety. That gives the breeders exclusive control over selling, over using, over commercializing that new plant variety. Nobody else can do that. Only the breeder has the exclusive control of doing so. Or you have to get consent from the breeder. Right? So this plant variety act or plant breeders right gives the right to the breeder over the propagating material. It can be seed, cuttings, divisions, tissue culture. It can be cut flowers, fruit, right, of the new variety for a number of years. In order to qualify for these exclusive rights, the new variety must be uniform and consistent. The new variety should be genetically fixed and therefore remain the same from generation to generation. It should be stable, I think so. That's the best word. It should be genetically stable, and it should have that genetic characteristics which should be stable through one generation to other generation. It should not have been commercialized for more than 1 year in the country of protection. It should be different from all other known varieties by one or more important botanical characteristics, that is height, maturity, color. It should be altogether a new variety. Then if your variety is fulfilling these important parameters, it is qualified as a new variety, and you will the breeder will be given exclusive right under the plant breeders right. Now, as per International Union for the Protection of New Varieties of Plant, there is an International Union, UPOV 1991. As per the International Union for the Protection of New Varieties of the Plant, the breeder gets a minimum of 25 years protection in case of trees and vines, and 20 years protection in case of other crops from the date of granting the plant breeders right. So that is a protection of 25 years and 20 years in case of other crops. This is a summary of all the different durations of different IPR, which although I have talked about. Patents, 20 years from the date of filing of patent application. Trademark registration, 10 years from the date of making of the application. Copyright generally lasts for a period of 60 years in India. However, as per WIPO, beginning with the creation of the work and lasting for not less than 50 years after the creator's death. So there's a difference. The registration of a geographical indication is valid for a period of 10 years. Once industrial design is registered, and a registration certificate is issued, The term of protection is 5 years, as I told you, which can extend with fees up to 15 years. Duration of chip layout design is for a period of 10 years from the date of filing for registration. Similarly, for registered new plant varieties, it is 25 years for trees and vines and 20 years for other crops and extent varieties. So this is the Indian legislation. If we talk about patents, it's Patent Act 1970 with all the recent amendments. Trademark Act 1999, Copyright Act 1957, Design Act 2000, Geographical Indications of Goods Registration and Protection Act 1999, Protection of Plant Varieties and Farmers' Right, Readers' Right 2001. So creativity is protected by IP from morning to night. We all know IP has given us so many advancements in science and technology, so that from the morning to the night, we are actually surrounded by all these IPs, starting from patents held by Edison and Swan on electric lighting and plastic, patents held by Bakelin, to ballpoint pens, patent held by Biro, and microprocessors held by Intel, Apple, Samsung. So it has actually revolutionized the whole world and increased the quality of living altogether. Now let's go into overview on the need to promote and protect intellectual property. The progress and well-being of humanity rests on its capacity to create and invent new works in the area of science, technology, and culture. Second, the legal protection of these new creations actually encourage the commitment of doing more work. So if you have IP actually not just protects you others from copying your work, but also rewards you in terms of monetary benefit. For example, if you own a patent, you have the freedom, the liberty to sell that patent to an industrial company for a particular period of time, to give the license of that patent and enjoy the whatever royalty you have been decided. So in terms of monetary benefit also you are getting something, and it is acting as a encouragement, a motivation to other people and the scientific community to do more innovation. The promotion and protection of intellectual property spurs economic growth, creates new jobs in industry, and enhances the overall quality and enjoyment of life for a common man. An efficient and equitable intellectual property system helps all the country to realize the intellectual property's potential as a catalyst for economic development and social and cultural well-being. In the end, the intellectual property system helps strike a balance between the interests of innovators and public interest, providing an environment in which creativity and invention can flourish for the benefit of all. Lastly, let's go through the important, as we had started, WIPO, World Intellectual Property Organization. World Intellectual Property Organization, or WIPO, was established in 1970. It is an international organization dedicated to ensure that the rights of creators and owners of intellectual property are protected worldwide, and inventors and authors are recognized and rewarded for their hard work and for their out-of-the-box thinking. WIPO is one of the 17 specialized agencies of the United Nations located in Geneva, Switzerland. It has 185 member states and 68 intergovernmental organizations and 232 NGOs, international NGOs, and 63 national NGOs working. What is the mission of WIPO? WIPO mission is to promote innovation and creativity for the economic, social, and cultural development of all countries through a balanced and effective IPR. IPR has to have, it's very essential to maintain a balance between the reward given to the owner of the IPR and the public interest. So that balance has to be maintained. The role of WIPO includes working with member states to support a balanced evolution of international IP law and administrating treaties, assisting the government and organizations in developing the policies, structures, and skills needed to harness the potential of IP for economic development, and to service the global registration systems for industrial design, trademarks, and the global filing systems for patents. So actually this WIPO is responsible for maintaining uniform guidelines and uniform laws related to IP in all its member states and to promote IP at national and international platforms. It also, in addition to those roles, is also it's very important role that is played by WIPO is to provide dispute resolution services, to coordinate and develop and further strengthen the IP infrastructure. It also provides a large number of e-learning courses, free. WIPO provides sources of large number of e-learning courses which anyone can get registered and know about from starting from basic course to medium level course to high level course, so that the IP information is for the young people and for the in all the member states is actually strengthened. So e-learning is also provided by WIPO. International cooperation on building respect for IP, World Resource Source for IP Information Analysis, that is e-learning sources, an efficient administrative and financial support structure to enable WIPO to deliver its program, providing a forum for informed debate and for the sharing of IP knowledge-based solutions so that everybody can get the benefit of IP. These are the references. Thank you all, and I hope this has added to your knowledge. Thank you.